I'll apologize. Having some technical difficulties getting both audio and video. I'm going to try and get that working during the course of the meeting, but we will proceed without you getting to see me so that we can get started. Can the clerk please call the roll?
Certainly. Member Caffrey,
Here.
Member Colley,
Present.
Member Cuniff,
Here.
Member Kelly, Member Martinez,
Here.
Member Selden, Chair Marks.
I'm here.
We have a quorum.
Okay. Okay. Our next item of business would be to review and approve the agenda that's been prepared and presented. Has everyone seen the agenda? And if not, let me know. And if there are any comments or changes to the agenda, please let me know at this time. Hearing none, is there a motion to adopt the agenda as presented?
I move it.
That was Mr. Colley. Is there a second?
I second.
Okay. Was that Mr. Cuniff?
Martinez.
Martinez. Oh, your eyes not showing up on the screen. Oh, thank you, Mr. Martinez. Clerk, please take a vote.
Member Caffrey,
Yes.
Member Colley,
Yes.
Member Cuniff,
Yes.
Member Martinez,
Yes.
Chair Marks.
Yes.
You have a due pass.
And next we have the minutes from our last meeting, February 12th. Are there any changes? Hearing none, is there a motion to adopt as presented?
I move we adopt.
Mr. Colley,
Second.
Mr. Martinez. So it's been moved by Mr. Colley and seconded by Mr. Martinez. Will the clerk please take a vote by name?
Member Caffrey,
Yes.
Member Colley,
Yes.
Member Cuniff,
Yes.
Member Martinez,
Yes.
Chair Marks.
Yes.
You have a due pass.
Okay. Next we have a discussion of the Office of Internal Audit process for the 2025 election. And will that be you, Mr. Rocha, or Mr. Watson?
Chair Marks, we actually have Office of Internal Audit on. Marissa Vargas is here to represent the office.
That's perfect. Ms. Vargas, please proceed.
I've also brought Vanessa Meski. She's actually the lead auditor who will be leading this effort. And we have prepared a one-page slide to share with you.
I'll go ahead and share that slide. Just give me one moment to pull it up. Having some technical glitches back here, but let me do a spot check. Can you folks see a PDF?
Yes, we can.
Yes.
Okay. Well, thank you, Mr. Chair, for the opportunity to meet with you folks. My name is Vanessa Meski, and I'm one of the auditors for the Office of Internal Audit. And today we wanted to basically provide an overview of the deliverables that our office will be providing for the upcoming qualifying contributions examination. As you may or may not know, a couple of years ago, our office was tasked to conduct audits on a percentage of qualifying contributions that are submitted by the candidates, 5% to be exact. So I went ahead and put together this very high level overview of the elections and what our office intends to verify. So in regards to the upcoming elections, the positions are for the mayor as well as the city councilors in districts 1, 3, 5, 7, and 9. So as you can see, we have a pretty big election year. And with that, the table that you're currently looking at, you'll see left to right the proposed type of financing, the candidate's name, their corresponding election race, the amount of qualifying contributions unique to their election race that they must obtain, and then of course the required 5% of the qualifying contributions that our office will attempt to verify. And then further below details the exact information that we will verify for accuracy. In short, our office will basically go out in teams of 2 and we'll go ahead and visit a voter's residence and confirm their identity, their first and last name, confirm whether they reside at that said location, verify their signature, and then also confirm whether or not they contributed a $5 donation in support of the candidate's campaign. So all that to say, we wanted to take this opportunity to ensure that the board is in agreement with our approach and ask if there's any information you think should or should not be included. Just any feedback and guidance is greatly appreciated. And I just would now like to respectfully open for questions.
Any questions from the board? This is Chair Marks. I have a question. When you say you verify the signature, do you ask the voter to look at the signature and confirm that it's theirs, or is it the auditor who tries to identify whether the signatures look the same?
Oh, thank you, Mr. Chair. That's an excellent question. So our office will go ahead and print out all the hard copies of the qualifying contributions. And yes, we'll indeed show the registered voter an overview of it and have them verify visually themselves that it's indeed their signature.
Okay. And in the information on the screen, we have 2 city council candidates. Does that reflect all the candidates that we will have for the election, or that's just the ones that have filed paperwork so far?
Paperwork so far, sir.
Okay. And remind us, please, which council districts are on the ballot this year?
Yes, sir. It is districts 1, 3, 5, 7, and 9. And I just want to confirm with Cristobal, just to make sure I have that correct as well.
Yes, Chair Marks, that is correct. And actually, I have a little bit of an election update here later during the meeting.
And one more, let's stay on this for a second. The 5%, is that something that the Office of Internal Audit has selected, or is that something that's required by rule?
The latter, required by the charter. In the I can expand on that further. In the charter that was codified a couple of years ago, it was required for our office to verify at least 5% of the qualifying contribution threshold unique to the type of election race. So that's how you can see some of them, of course, differentiate. And then I can also speak to the very first one. You'll see that asterisk for private. Our office is not required to verify the private type of financing, only the public.
Okay. So the rule would not prohibit looking at more for the city council?
Well, we could. And so that's kind of definitely why I wanted to meet with you folks, just to kind of get a sense of, yeah, whether or not you do maybe want us to expand it a little more. Because also when you're in the trenches, the meat and potatoes of it, we'll make 3 attempts to 1 residence that is randomly selected. And we'll make those 3 attempts as long as the residence is accessible and of course non-threatening to our staff. And in the event we're unsuccessful, we're just, the folks aren't there, we can always perform a reselection, what we call, which would, of course, for example, this total of 983, it could go up gradually if we are performing reselections.
Right. It was a really long time ago that I was an undergrad taking statistics, It would have been probably 1978. Probably most of you weren't even alive then, but my recollection is that the sample size is a lot more important than the universe size. You know, you can predict a presidential election with a sample of maybe 800, and you can predict a mayoral election with a sample of 800. You can't, I think 20 is on, from what I recall, 20 is on the borderline between what you would use the t-test for, and then you get to the normal distribution once you get a little bit above that. But just from a more common sense perspective, you know, if there's going to be, you know, if there's fraud or just sloppiness in a campaign, it's not going to affect every qualifying contribution from what we've seen in the past. I mean, they haven't been wholesale all wrong. There's been an error rate, but and I'm trying to remember what the error rate has been, but on the ones you sample, but would it be fair to say it's around maybe 5% when you when there are ones that don't qualify, Ms. Vargas? Is that what we saw last time?
Vanessa, correct me, but in our previous effort, we didn't have any issues, correct?
Correct. We didn't have any issues.
You didn't,
There was a previous investigation that the Office of the Inspector General completed, but I couldn't speak to the details
Yeah.
of that or the error rates that they identified.
I think would that have been the prior mayoral race? Because I do recall we went to a hearing
Correct.
and I do recall there are questions as to whether, you know, I don't know if we even came to a conclusion, but whether people had in fact done the ones they said they would. But in any event, I'd feel more comfortable if we went up a little on the council races to be sure that that you know that you're catching things, and you know, looking at this display, it doesn't look like it would be that much more effort and cost, but once those all get populated, we're talking a significant amount more candidates. But if we just added 10 to each one, it would still be probably the same as one mayoral candidate.
And then, Mr. Chair, if I can interject, also, we're limited by our resources, by
Yeah.
how many staff that we can do, because
Yeah.
we do have to visit the homes.
Yeah.
And so that 5% provides us a buffer. At a minimum, we have to do the 5%. But if we do note any like anomalous forms or behaviors, that allows us also to expand sampling, maybe for that one candidate or that one district.
Okay.
So we do have the ability to do more. And so it's maybe more risk-based as we add sample items to this assessment.
All right. Oh, thank you, Ms. Vargas. That's a good clarification. So, and you know, if we had to do it all over again, I think maybe the 189 is overkill for the mayoral candidates. You're gonna, if there's half that, would let you know if there is going to be an issue probably, but we're stuck with that by the rule, correct?
Correct.
Okay. Well, with that clarification that the Office of Audit will take into consider risk and increase sample size if there's reasons to be concerned, I'm comfortable with what you proposed.
Okay, great. Thank you.
Any of the other members have anything else to comment on this at this time? Hearing none, thank you, Ms. Vargas, and thank you again. I recall that we were very pleased with the thoroughness of the reports from the last electoral cycle, and looking forward to the work of you and your staff again.
We appreciate the opportunity to present to you today, and so thank you. I'm sure we'll be talking shortly here in the future.
All right. With that, we are now on item 5, which is the advisory opinion request 01/2025 from Safer Albuquerque, which is what I understand is a Measure Finance Committee. And the Measure Finance Committee has asked the board for an advisory opinion, which is available pursuant to our rules, as to whether a disclaimer in the body of the advertisement is required for a digital billboard, which would be procured from Clear Channel, I believe, and disclosing in the body of the advertisement Clear Channel's name, which Clear Channel does not wish to have happen, lest it be perceived to be endorsing the content. And at my request, staff sent the request for advisory opinion to the council, to the lawyer that's been engaged for this type of work. It was Mr. Jackson, and he's here with us today, I believe. And before we put him on the spot, if Mr. Rocha could please review the timelines we're under with respect to this advisory opinion.
Absolutely, Chair Marks. So the advisory opinion was submitted. Once it was submitted, the board council had 14 days to submit a draft to the board, which would have been yesterday. The board itself has to act upon the draft advisory opinion within 30 days of its receipt. And the board may adopt or decline to adopt the draft advisory opinion. If so, the board delegates to the clerk the obligation to update the requester in writing every 30 days until the advisory opinion is issued. Chair Marks, we also have the requester here with us in the meeting as Charles Rollison.
Okay. Any questions about these timelines before we get to the substance? I mean, why don't we? I think we should go to Mr. Jackson. We don't have it on the agenda. We're able to take public comment, I suppose, but I'd prefer that we not hear from the requester. We're going to work from the written request, unless there's some objection there. Okay, with that, let's have Mr. Jackson.
Thank you, Chair. So the issue here is really about characterizing a digital billboard advertising placement for purposes of the regulations that the clerk has promulgated as permitted by the charter for the election code. The charter has its own disclaimer provision, which requires a clear and conspicuous disclaimer stating information on how the material was paid, and any additional information as required by the rules promulgated by the city clerk. And there is a revised rule set for the 2025 election cycle that the clerk has promulgated that gives a little bit more meat to those required disclaimers. And the way that the clerk has broken that out is that there are printed campaign materials, there are broadcasts, which is further subdivided into audio and video, and then there is what I'll call a digital, and it would include text messages, email, phone calls, as well as social media and website advertising. Now, of course, we've had billboards for many years, and typically what happens is that the person who wants to have their content on a billboard, they purchase the space, and then the billboard is printed on vinyl or other material, and you'll sometimes see people out there with the big roller putting the billboards up. And billboards are included as an example of printed campaign materials in the rules. Digital billboards operate a little bit differently. It's a little bit more like just the computer screens that we're all looking at today. Now, we haven't done any independent investigation, but on the facts as they're presented, Clear Channel has, well, the requester has told us that Clear Channel says that all that happens is that the advertiser here, the Measured Finance Committee, will submit the digital content to Clear Channel, and then Clear Channel just uploads that to their billboards in rotation with other advertisements from other entities. So that doesn't really seem to be caught expressly within the rules. So we had to determine what is a digital billboard advertisement? Is that printed? It doesn't seem like it's printed because it's there's no fixed media. Once the digital billboard rotates to another advertisement, that content is gone until it comes back up. It only lives in a digital form. So based on that, what this advisory opinion proposes is treating digital billboard advertising as it would basically a website, just a website on a really big monitor. And that would not include requiring identifying the printing establishment, because there's not meaningfully a printing establishment here. But it would include the requirements for the disclaimer for electronic media, which would principally be the name of the committee. And that is sort of the high level view of this. If there are specific questions regarding the opinion or comments, I'm happy to take those from the board.
So I have a question about if this provides enough direction to the requester. So I'm fine with the logic of that this is more like a website than a vinyl billboard. The part of the regulations about what disclaimer has to go on a website does not have anything about the size of the disclaimer relative to the other print. Is it 5% of the largest font, or is it 10% of the largest font? Because by the time you get to a large billboard, I mean, we have to have kind of a relative size for what the font of the disclaimer is, so that it can be at least somewhat seen. So, but I don't see that in the regulations themselves that would apply to another form.
Member Caffrey, I believe that for purposes of analyzing the sufficiency of a disclaimer, either for the committee itself in preparing the materials that it would be submitting to Clear Channel, or for the clerk's office in determining whether the disclaimer is sufficient, it would be treated much like a website, in that which the website, if you've got an advertisement, that goes up on websites, you've got to clearly identify the committee or the candidate. But then the background for that is, of course, the charter provision, which is clear and conspicuous. And yeah, that doesn't have specificity, but it's not a 5%. It's not, this has to be it has to be 10% of the ad or 5% of the ad, and it's got to be in the same text as the other ad. Is sometimes you see in require regulations for disclaimers, but that clear and conspicuous would be the guidance that
Mhm.
have.
Okay, it seems like they asked for an advisory opinion, so they're obviously concerned with complying with the regulations. So I guess that would provide sufficient direction to them to just make that disclaimer clear and conspicuous.
Mr. Chairman, I had a question for Mr. Jackson. I think that you were tasked with a difficult assignment because it doesn't seem to me like these provisions really contemplate this scenario. And I think my sort of gut reaction to it is that a billboard, whether it's electronic or printed, is qualitatively the same thing. And I understand sort of that the rules seem to focus on the nature of the media as the distinction for how the regulation is crafted. But I would also note, and I promise there's a question, that this sort of category of digital media includes what I believe to be non-digital media too, things like telephone calls. So I think that is even arguably somewhat murky. I wondered, Mr. Jackson, if when you were looking at the regulation in the section A there, where it says small a printed campaign materials, and then there's I, and then there's small a in a parenthetical and small b in a parenthetical. And I want to point your attention to that provision. It says the name and address of the establishment that printed or otherwise created. And that otherwise created language sort of caught my eye as a suggestion that maybe the sort of title printed campaign materials doesn't altogether limit the scope of what's included in that provision if it also includes otherwise created materials. And any thoughts on that?
Sure, Member Cuniff. The otherwise created, again, on the facts as presented by the requester here, the understanding is that Clear Channel does not actually create the content. The content is created by the committee, and then just provided to Clear Channel, which simply uploads it to the sign itself. So the printing establishment or otherwise created establishment under these facts would still not be Clear Channel. And there are the two options right there for the printed or otherwise created. One is either the name and the address of the printing establishment, and Clear Channel here would not be on the facts as presented, is not a printing establishment, and it's also not otherwise creating the material. But because it's digital, it's also not clear that the campaign is printing, so it's not clear that the A1B2 for the in-house disclaimer would apply there.
What is your sort of reaction to the more qualitative analysis that and sort of an e-billboard and a traditional rolled out billboard have the sort of same impact on the public? And if the underlying policy, and I don't know what the underlying policy, but if it is that billboards are of such a nature that this disclaimer is appropriate, wouldn't it apply regardless of sort of the nature of the billboard?
Member Cuniff, I'm not sure that that's accurate in this particular context. One problem is, of course, that we're dealing with the rule set that we've got, which doesn't really contemplate this distinction. I would agree that the member of the public probably does not perceive a digital billboard significantly differently from a traditional printed billboard. But the animating policy here which is inferentially sort of a belt and suspenders on who's paying for this, who's making it, and ultimately how is it reported. There's a separate provision in the rules that deals with in-kind contributions in the form of printing materials, in which that is synergistic with the printing disclosure requirement for printed campaign materials. But again, when you're talking about printing, there are a couple of issues to bear in mind. One is that there's a cost associated with that, right? Because you've got tangible materials that are printed and consumed in the course of printing that you don't really have in the digital context. I mean, you've got the electric bill, but that's going to be the electricity is going to be on irrespective of what advertisement is running. So the marginal cost associated with the digital is going to be lower for Clear Channel here, the billboard owner. And then in terms of identification, the digital billboards that we see are new, and most of them do have, for reasons unrelated to this, they identify the billboard company on the frame itself, as a way to pitch their billboard services. And that's the case here. This advisory opinion does not reach the question of how the regulation would be interpreted for a digital billboard that does not include the label on the frame itself, as Clear Channel does.
Why is it, I see you included in this excerpt of the regulation, A1B broadcast campaign materials. I assume that B2 doesn't apply because this isn't a broadcast. Is that right?
Member Cuniff, I included broadcast materials because I think that is that's a question. Again, you're trying to figure out which of the existing boxes does this fit in. And although the website box seems to be the most appropriate box, video broadcast would probably be the next most appropriate box. It's a little bit different from what most people would consider a video broadcast because it's static. At least
are they per se static, or can they have like a clip? Could it play like a 10-second clip continuously?
There are regulations related to highway safety that preclude
Okay.
use of video in these things.
Okay. And I think that the thing that I'm struggling with, and maybe this has sort of been implicit, is I read it, under either A1A or A1B, that disclaimer with respect to who created the billboard would be required, but under Section E, the requirement for the disclaimer is only related to the financing of the billboard, so the disclaimer isn't required there. Am I reading that right? I'm saying essentially that the nature of the disclaimer is different under A1A and A1B, and that it requires the entity that printed or created the advertisement or the materials to be identified, but under Section E, the disclaimer is only with respect to who made or financed the expenditure. So a different requirement, right?
The language is certainly different. On these facts, I'm not sure that there is a distinction.
Yeah.
Because the cost of preparing it is borne by the Measure Finance Committee.
Because if it said in E for who made the media or finance the expenditure, then I think that would clearly require the web designer to identify themselves in addition to the PAC or whomever funded the materials. But as I read that, it looks to me like it's only the entity that finances the I don't know, creation and distribution of the materials. Thank you, Mr. Jackson. Good work on this. I appreciate you walking through it with me.
Certainly, and one thing that I would note before this gets finalized is that as I am reviewing it, it appears that there may be some numbering glitches resulting from Microsoft Word's list feature, where once you get like D4, I think that's probably D1, but we'll revise that to make sure that it tracks the numbering of the actual regulations.
Well, thank you, Mr. Cuniff. I have some of the same feelings. I know this is a very heavily lawyer legal thing, but our non-lawyer members of the board are quite perceptive people and would be and certainly welcome to weigh in. Mr. Martinez, Mr. Colley, if you have some questions or thoughts, Mr. Colley, Mr. Martinez.
No questions for me,
Okay.
Mr. Chair. Thank you.
Okay. Hopefully I haven't left someone out here, but Mr. Jackson, I gotta say my gut reaction is the same as Mr. Cuniff, that a digital billboard is more like a vinyl printed billboard than it's like a website. And as to the policy, just a little bit of background here. The state statute that you quote in the advisory opinion is the current state statute, and I looked at it and I was surprised because when I used to run for state office, the state had a requirement that you, back 15 years ago, that you disclose the printer on a, if you had a 4x4 sign or a handbill or whatever, you had to give the printer, and you no longer have to do that under the state law. And I'm going to assume that back in the day, there was an interest in knowing who the printer was, in case in case you had trouble figuring out actually who was the sponsor and the paying person. You could go to the printer and say, hey, who actually hired you to do this? Because clearly, we don't, we don't assume that the printer endorses the message. The other, but at some point the state legislature apparently decided that it was no longer necessary to identify the printer. What was important was to say who paid for it, who the actual sponsor was. The other thing I noticed in the both what the old state statute, but the current Albuquerque laws are, if it's a newspaper, if it's a TV ad, it's not required that you separately name the printer or publisher, since it's obvious. If it's in the Albuquerque Journal, there's an ad there, it's the Albuquerque Journal because you bought that newspaper. And if it's on KOAT or KOB, you don't need that information because you know what station is on. And the situation here is we have a billboard and it says, at least for this particular company, as it says Clear Channel on the frame underneath the billboard, likely for the reason that Mr. Jackson says, is that the billboard company wants you to know who they are so that you can call them and put your own billboard up and pay them. So I'm not sure how we fit it into, there's a strange question, as everybody has remarked, including Mr. Jackson. It's not exactly in the regs anywhere, but clearly the intent is satisfied by, you can see it's a Clear Channel billboard because they have their name on it, but that printing might not be big enough under the regs. I'm not sure. But I think probably, and I went looking, and either Mr. Jackson or Mr. Watson, if he's on here, I think, is one way to deal with this, just to give a variance from the regulation and say that the intent of the regulation is met because the billboard includes the name of the billboard owner, and that's sufficient, even if it's maybe not technically compliant with the size and printing requirements. But that's a complicated answer, and I think maybe the better answer, the easier answer, is Mr. Cunif's, which is that we determine that in this context, it's sufficient to disclose the creator, which is not Clear Channel, but it's the Measure of Finance Committee, and not make any kind of an advisory opinion that a digital billboard is like a website. And I sure would like to hear from somebody who says, completely the opposite, that what this Safer Albuquerque wants to do is not, if anybody believes it's not permissible and the only way for them to be legal is to make Clear Channel include within the frame of the billboard Clear Channel's name, speak up and we can consider that. It sounds like those of us who have commented so far agree that what Safer Albuquerque or wants to do should be legal, but the question is why. And as to the why, I favor Mr. Cunif's approach, which is that we would deem Safer Albuquerque to be the creator, and that this is something where it's creator, not printer, and that the law is satisfied on that basis.
Chair Marks, I do have a question for clarification, and then also just a little bit of historical background. So when you suggest saying that the committee here would be deemed a creator, and that the regulation would be satisfied, would that include saying that the digital billboard is considered printed campaign material, and so the creator requirement is satisfied, or that because the creator is identified, it is satisfied regardless of which provision of the regulation that falls under?
I'm with Mr. Cunif. It's printed. A text message is a written communication today. I mean, 20 years ago, it just seemed weird to me, but you can make a contract by a text message, and it's the same as what we used to do with the typewriter and a piece of paper. I think the operative thing is if it's a two-dimensional, I haven't really thought about it, but website is printed. What's not printed is a radio ad, a telephone call, a robo-dial call, or a audio ad. I think that's the distinction. If it's got words, if it's got words written out, it's printed. I don't know. Does that make sense, Mr. Jackson, Mr. Cunif?
To me, that does not make sense as a distinction. To me, the distinction is the practical effort required to disseminate the materials, which is always harder if they are literally printed versus a digital or phone call. So I mean, a website or a digital billboard does not require the same physical commitment to reproducing the image. So to me, that's the distinction and why I'm fine with the logic that this is equivalent to a website, a much, much, much bigger website. Because there's, if someone is printing a material, that's a lot more of a practical investment in time and materials. And so I assume also in permanency, a physical printed billboard, a vinyl one, would be a lot more permanent because it has to be printed and then put up and taken down. A digital billboard can change, and driving down the freeway, you can see them change. I don't know what the schedule is, but they can be changed with the click of a button. So to me, that's why why the logic of this advisory opinion is sound.
Okay. And I'm not, like,
Then
I
Chair
haven't
Marks,
heard from anyone.
I'm sorry.
Excuse me, Ms. Jack. So we're gonna move this to a conclusion, I think. But I haven't heard from anyone, and I'd be clear, there's a last chance if a member thinks that this is completely wrong and that the opinion should be that Safer Albuquerque or requires the name Clear Channel and the content, speak up now. Otherwise, what we're going to be doing is we're going to vote on the two alternatives that would both result in an advisory opinion that would tell the requester that what they're requesting is permissible. There would just be different bases. So I want somebody to speak up. Mr. Alden?
Chair Marks?
Yeah.
Yes, one point of interest here is that if the board elects to reject the advisory opinion as written, it would need to be rewritten either by Mr. Jackson or by someone on the board. And so it should just be noted that whatever position the board takes will need to be memorialized in that way.
Okay. And thank you for that clarification. Let's see what we want to do, and I don't think I think it's more important to get it right in the sense of the board than to worry if who has to do a little more work, as long as it's not me. So what I've heard, I think the simplest way to do this is for Ms. Caffrey. You support the advisory opinion as drafted. If you would make a motion, and then we'll see if there's a second, and then we'll vote. And if that motion doesn't pass, I'll ask Mr. Cuniff to make a alternative motion, assuming he's still of that mind, and we'll vote on that, and hopefully we'll have a resolution.
Okay. So then I move to adopt the advisory opinion on the subject of the disclaimer for the requester. What's it called? Oh, the requester Safer Albuquerque.
Thank you. Is there a second for Ms. Caffrey's motion to adopt the draft? I think the motion then fails for lack of a second. Mr. Cuniff, do you want to make a motion?
I think the struggle, Mr. Chairman, that I'm having is fitting it somewhere else within the regulation. And I don't know if it's appropriate for us to decline to issue an advisory opinion. We don't think the rules contemplate the scenario. And then essentially, and perhaps unfortunately, the entity at issue just sort of absorbs the risk. But I feel, I think it's for me closer that it is within the scope of the printed campaign materials. And another reason that Section E gives me pause is it seems like that list in what is identified as number 4 is an exhaustive list. In other words, it's not a list of exemplars, it's a defined list. meaning that the provision only applies to those items enumerated. And, and e-billboards are not enumerated there. So, again, that gives me further pause, but, I'm also reluctant to say, and I think this is probably the challenge that Mr. Jackson confronted, reluctant to say that it fits in the printed materials section. And I guess we always want to do something. We always want to have answers, especially when you're involved in regulation, but sometimes regulations don't contemplate various scenarios. And I think it's appropriate to say that. And then perhaps contemplate additional rulemaking. So I'm sorry, that's not very satisfying.
No, it isn't. I thought you were gonna lead us to the promised land. So, Mr. Cuniff, so if, assuming, working off the numbering in Mr. Jackson's draft on page 4, if the board was to believe that this is a printed campaign material under 1A double I billboard, correct? And under 1A small I1B, you don't think it would be sufficient to say that the board finds that a billboard's a billboard, but that in this circumstance, the disclosure needs to be the creator, which is the Measure Finance Committee, not Clear Channel? Because it says the following exceptions include, so there it's not the Latin for whatever it is, ex exclusio, whatever it's called, I can't remember, but those are exemplars potentially, and this is analogous to a newspaper. It's clear who's, it's somebody else's property, permanent property or long-term property. So back to it, that would be where I'd go. I'd say this is a printed material, but it's satisfied by a disclosure of the creator, not necessarily the printer, the creator being the Measure Finance Committee, not Clear Channel, when the physical billboard makes it clear who owns it.
Mr. Chair, if you will make that motion, I will second it.
Okay, I'll do that. I want to get, and if we vote it down, we're going to send it back to Mr. Jackson and he'll bring something else back to us. But I make a motion that we revise the draft opinion to make the basis that this is a billboard, but the requirements of law are satisfied by identifying the creator, not the printer. And the creator is the Measure Finance Committee when the billboard has indicia as to who owns it.
Mr. Chair, I second that motion.
Right. Okay. Is there any discussion on that motion?
I do have a couple of points of interest on that motion, Mr. Chair. The first is that the city charter, Article 12, Section 3H requires that if we kick this back for revisions or a new advisory opinion, the board will have to meet within 14 days to consider it. So just be aware of that. Okay. Also, as a general matter, when kicking an advisory opinion back for revision, especially to independent counsel, it's important to make sure that the independent counsel is comfortable professionally with making those revisions. So just some things to consider in the discussion.
So back to, are you saying our only choice is to either adopt the draft or to send it back to be redrafted? We can't we can't adopt an advisory opinion based on what we heard today?
There isn't a the only advisory opinion in front of the board for consideration is the one that Mr. Jackson prepared. You know, the board has discussed ways in which it would like to have that opinion revised. It's kind of stated the position of the board, but that didn't create the written revisions to the advisory opinion, so the board can't formally adopt what isn't in front of it, if that makes sense.
Well, I mean, it does, and I mean, if that's what our statute or controlling law literally says, then we have to follow it. I mean, in other circumstances, you know, if we were considering a statute or a reg, or a motion, we can change it, but here we can't. So, so the motion would be amended to say that, and that we would direct a new draft to be prepared and presented within 2 weeks, consistent with what the movement previously said. Is there still a second, Mr. Colley?
Yes, there is still a second.
And then Mr. Jackson, are you going to be able to, within your draft that without violating what you believe to be your obligations?
Chair Marks, that's not a problem. As I think the discussion makes here clear here, this is it's a little bit nebulous, so I don't think that an opinion that it seems to be the sense of the board rather than the draft would be you know, contrary to law anyway.
Perfect, because I can't do it. I'm not a lawyer anymore.
And Chair Marks, I just want to flag something for the board. Is member Caffrey has dropped off. I want to ensure that there is a quorum.
Oh, Mr. Rocher, can you call her on the
Sure.
cell and see if we can get her back?
Chair Marks, she emailed us and she said she has to go for a work event.
Okay,
But we do have a quorum. We still have
Okay.
4 members here.
okay, okay, let's take the vote and see what it is.
Can I just offer one additional point, Mr. Chairman?
Yeah.
I think I'm going to support your motion. My only question is it the better policy to simplify our direction to Mr. Jackson along the lines of A1A applies and just leave it at that, as opposed to adding all the additional content that only the creator needs to be disclosed? And that's sort of the approach that Mr. Jackson took. And I think a lot of times in drafting an opinion that is going to be sort of for general use, it can be better to include less details. And I can live with it either way, but it's just a suggestion.
Okay, so I'll take that as a friendly amendment, so long as we keep the sense that the thing that you originally brought up is we think that a billboard's a billboard, regardless of the technology. So we'll keep that in there and then simplify it and say that this is permissible under A1A, well, and the creator under A1B. We need to say the creator, I think. Because B is required. And not say anything else. Is that okay, Mr. Cuniff?
I think so. Thank you,
Okay.
Mr.
Let's with Mr. Rocha and Mr. Jackson, do you understand the motion as amended?
Chair Marks, I believe so, and if on redrafting I do not, I can come back to the video archive of this.
Okay. With that, Mr. Rocha, can you take a vote?
Member Colley,
Aye.
Member Cuniff,
Aye.
Member Martinez,
Yes.
Chair Marks.
Aye.
You have a due pass.
Okay, so what do people's schedules look like for 2 weeks? maybe the 23rd. Is anyone conflicted if we met on the 23rd at 1?
No.
Here. Hearing none,
Hey, Mr. Chairman, I have a deposition
oh,
every day that week,
oh,
but you should be able to get a quorum without me. So, and
Oh.
if I, and if I can, if we like do it on the lunch hour, and I'm gonna be in the same time zone.
can,
Otherwise, it's a hard week for me.
okay, can we do it at 12:30 to accommodate Mr. Cuniff? Anybody object to that?
No.
Chair Marks, my availability on the 23rd, if the board has additional questions for me on the subsequent meeting, is uncertain. There's a deposition scheduled there, but it looks like it may not go forward.
Is the 22nd better for you?
It is.
Anybody have a problem with the 22nd at 12:30?
No.
Let's do that, and hopefully the other members are available, but this way at least we'll have 4 of us. Right. Are you good with that, Mr. Rocha?
That works great.
Okay, sorry to mess with staff's lunch hour, but I think it's more important to have Mr. Cuniff available.
I think we'll make do, Chair.
Okay. Item 6, and thank you, members. Thank you, Mr. Jackson. Item 6, 2025 election and candidate update.
Thank you, Chair Marks. I do have just a brief update on a few bits of the 2025 election. So first, we've gone through this before, but just a reminder, the election timeline for the qualifying period, as well as declaration of candidacies. Mayoral candidates start their qualifying period as of next Saturday. Their period runs through June 21st. In the middle of that, City Council starts their qualifying period on June 2nd and ends on July 7th. Privately financed candidates will take their petitions and declaration of candidacy to the county clerk on August 26th. And if there are any write-in candidates, they'll file directly with the county clerk on September 2nd. Just a general brief of the election timeline. So first day of early voting is October 18th. Last day of early voting is November 1st. Election day is, of course, November 4th. And with the potential runoff is likely in December. We are still finalizing the date, but I have an understanding that it's more than likely going to be December 9th, with early voting starting the weekend of Thanksgiving. So currently, you saw the list earlier, but we have Mailing Armijo, who is a privately financed candidate for mayor, Eddie Varela, who is publicly financed for candidate for mayor, Patrick Size, Darren White, Timothy Keller, and Luis Sanchez, all also running as publicly financed candidates. You might have seen Daniel Chavez announcing his candidacy in the news. He's given me a brief phone call. Sounds like he's going to run private, but has not filed. The requirement to file is once a candidate has raised or spent $1,000, then they must file with their campaign finance reporting period. I've heard that he's sent letters, but I'm not exactly sure, where he is and his finances. And last, we've met with one other candidate named Alpina Adair, also a prospect candidate for mayor, but not exactly sure when or if she will file. We do have candidates for city council. The only two that we have are Chris Cedillo for District 3 and Anami Das for District 9. both city councilors for those districts we've met with, but they have not filed either. Just wanted to give you a quick verification flow. So we do verify registered voters for both paper qualifying contributions and paper petitions here in our office. Generally, we see most rejections being that the form is incomplete. That's the most likely. A lot of folks like to use quotation marks for whatever reason instead of fully writing their address if their spouse or other lives at the same address. So this will be provided to all candidates. It's also what our staff is working off of to determine whether or not they're going to reject or accept that those signatures or QCs. And that is my brief overview of the election. I know Chair Marks, we had talked about doing just quick updates every meeting. So I will, as candidates file or as the tallies for qualifying contributions, petitions come in, I'll review that with the board as well.
And so we'd be set to meet again on the 14th of May. We'll, because it's hard to anticipate what will happen, but there won't be any reports on qualifying contributions by then, will there?
We will have running tallies. There may be, if a petition or qualifying contribution is rejected, candidates have 7 days to rehabilitate that with our office. So there may be, rehabilitations that we can cover at that time. We can certainly cover tallies and where folks are with qualifying, whether petitions or QCs. And as well during that period, Office of Internal Audit probably would have gone out every weekend before, so there may be some information or returns QCs from their report as well.
Okay. So I'll put this to the members. Assuming what would be on our plate on May 14th would be reports which may either be everything's running smoothly or there are some issues starting to develop. But assuming that there is no matter that actually requires a vote of the board, do the members want to convene and stay updated, or would you like a month off if there's nothing that requires action? Let me know what you think so it's not just based on my preferences.
Well, I think that given we're going to have sort of this extra meeting, if there's no urgent business in front of the board, it makes sense to take May off, especially since I expect that our workload is, well, there's certainly the likelihood that it will increase significantly after that.
Thank you. Mr. Colley, did you have an opinion?
So Chair Marks, Member Colley just texted me. He's running very late for his medical appointment.
Okay.
So he had to leave. It does, at that point, we don't have a quorum, so I'm just not exactly sure how we adjourn, but.
Okay, well, it looks like we don't have, Mr. Martinez, this is not, I think I could still get your opinion on scheduling a meeting. Are you with Mr. Cuniff on that? Take the month off if we don't have anything we have to do?
Yes, that's fine. Will Mr. Rocha still send the update via email about candidates or not
Sure.
able? Yeah.
Let's do that, Mr. Rocha. I'll meet with, and we're certainly not able to conduct business right now. We lost our quorum, but I'll just inform the members who are on that I meet every month, a week before the meeting with Mr. Rocha and Mr. Watson. And if we have nothing that's urgent, requires our action based on the feedback, we'll not meet in May, and I'll just direct Mr. Rocha to send an update so people stay informed. With that, let the minutes reflect that the meeting was ended due to the board losing quorum. And with that, I thank everyone, in particular Mr. Jackson, and Mr. Aiden for keeping me honest and compliant, and wish everybody to have a good afternoon. Thank you.
Thank you.
Thank you.